Hello everyone, I'm Arnie Clarke. This is the last in our 2020 series of expert talks on IP from Gill Jennings and Every. You'll find the rest of the recordings on our YouTube channel. I'm a patent attorney and partner at Gill Jennings and Every. We're a specialist IP firm based in London and Munich, and I am a specialist within that firm at handling European oppositions and appeal procedures. I've been involved in over 300 oppositions and currently spend a significant portion of my life based in Munich and The Hague attending hearings, about 25 hearings a year. I also handle contentious cases involving parallel proceedings in multiple European jurisdictions, so to support national litigation. And this video should help you make a better decision as to whether you should file an opposition and how you should run it. So I've actually entitled this an impractical guide. Now, the reason for that is I'm not going to tell you how to do my job. I'm not going to teach you how to actually run an opposition. Rather, I think it'd be more helpful for you if this is focused on how you can make better decisions as to what you need to do, whether you should file an opposition, and to give you an idea of how you can help in order to make sure that you get the most out of this procedure. So I'll be offering a strategic view of the opposition system, and what we're going to focus on today is what it is, why you should use it, if at all, an outline of how it works, and to avoid the many pitfalls. I say the many pitfalls. A lot of people come into the opposition procedure expecting it to be just a continuation of the examining procedure that you go through in order to get your patent granted. It's not. It's got a separate set of procedures associated with it, a hell of a lot of case law. And so do not treat this as just an extension of how a patent got to grant. It's very separate, and that in itself creates a lot of pitfalls for even seasoned practitioners, but certainly unseasoned ones. So I'm going to start by discussing what it is. So in the same way as the European patent system, the EPC is for the granting of European patents, which is a centralized system where you file centrally, examine centrally, and grant centrally. The opposition system is a similar centralized procedure, and but in this case, obviously, it's an invalidation procedure rather than a patent acquisition procedure. They're adversarial proceedings, as I'm sure some of those who are online will have noticed. At some point, you are going to literally come face to face with the person or the company on the other side in a hearing, unless you filed anonymously. But you are battling the other side rather than the EPO in this procedure. They are, however, time restricted oppositions. You must file within a window of 9 months from grant, and there are no extensions, no exceptions to that. If you miss that, you can't use this procedure. That's in contrast to a lot of national procedures where you can challenge the validity of a patent throughout the lifetime of the right. And another thing to notice is that the grounds of opposition are slightly limited compared to the grounds or the standards that were applied to getting the case through to grant in the first place. Most notable of that is clarity requirement, Article 84. You can kind of understand why the EPO has excluded that as a ground of opposition, because I'm sure there are a few lawyers listening to this. We can all make an argument as to why a claim is, or a term of a claim is unclear. And so I think that's got rid of a lot of vexatious oppositions and arguments as to why a patent shouldn't be maintained. And how extensive is this? Well, about 5% of European patents are opposed. I think that runs to about 4,000 patents a year. So it's widely used. And I think all of this says from the EPO that the EPO is not infallible. It accepts that it's not going to find all of the prior art, especially things like prior use. And therefore the opposition procedure is there to make sure that invalid patents are kept off the register and allows the public to police that to some extent. So what are motivations for filing an opposition? This should be relatively obvious in many ways. It's a clearing the way exercise, it's freedom to operate. This system allows you to revoke the patent in all effective European states. This only applies to European patents, I should have said earlier. So it's not national patents, it's only European patents, but it lets you get rid of the patent in all states in which it's been designated. It's often filed in expectation of future patent litigation. So certainly I've got experience of oppositions being filed to test arguments and evidence that were going to be used in later litigation. It's also used by not just national European jurisdictions, but also overseas. So for example, I know that I've got some US clients who like to file an opposition or have filed oppositions in order to test the outcome of the case in Europe before it really hots up in the States. So that can help flush out the strategy and the tactics of the other side and how they're going to run essentially this pseudo litigation. And it can be used to achieve an early settlement rather than having to get to national revocation proceedings, which can be pretty costly. One aspect which I think people don't pay enough attention to is the use of the opposition procedure to deliberately force narrower claims. Most people come into the opposition procedure looking to just destroy the patent, but actually there's a significant benefit sometimes, if it's possible, to reduce the scope of the claims and therefore give yourself freedom to operate, but keep competitors covered by the scope of the patent, which is obviously good for you. It's also good for the patentee, but it keeps potentially a large part of your competitors off the market. So if you can engineer that, and it's not always possible by any stretch, but if you can engineer that, that's often a good outcome. And of course, it can be used as leverage for negotiation for a patent license as well. Now, it's also, I've seen it used just to tie up resources. Sometimes you just want to deflect and to draw attention away from certain issues which are really important. There might be other patents that are of particular importance, but oppositions are filed simply to tie up resources and to draw attention away from what really matters. Any occasionally, I would say. And finally, I've actually seen oppositions filed simply for revenge. Disgruntled employees, disgruntled inventors. Some companies just don't like each other, and I've seen them filed simply because they can, and it's relatively cheap to do so. So people file oppositions for that reason as well. Fortunately, not as that often. It's only occasionally I've seen that. So what's the risk versus reward for filing an opposition? You've got a very good chance of success. I'd say this is not a patentee-friendly process by any stretch. You can see from the stats that are on the screen here that as an opponent, you've effectively got about a 70% chance of moving the scope of claims from where they were as granted. So 30% of cases will be maintained as granted, but the rest will either be maintained in amended form or they'll be revoked in their entirety. And actually, your chances get even better on appeal. The level of revocation goes up by a few percent. So you can see this is something that you've got a pretty good chance of getting somewhere with your opposition. And at least a third of the time, the case gets revoked in its entirety. And that is all at, I would say, relatively little risk. I think the vast majority of cases that I deal with are filed by the actual opponent themselves. You can file them anonymously. You file straw man oppositions to conceal the identity of the shy opponent from presumably the rapacious patentee. And we file straw man oppositions all the time. It's very popular. It's also a very cost-effective procedure, which I'll come on to shortly. But an aspect of that is that the parties bear their own costs. Now, obviously, that does have a cost implication, an obvious cost implication, but an additional cost implication that it has is that you can run vexatious arguments in the EPO, One of the questions that came through before I gave this talk from one of the people who's listening is, what sort of arguments can you run and how reliable are they? Even with experience, you often find that sometimes it's difficult to predict what will work. You're never quite sure what the EPO is going to decide. So it allows you to run marginal arguments with no real risk of bearing the cost of doing so, other than the time you put into arguing them. That's in contrast to a lot of national courts that will penalise you in costs for running arguments which really don't bear much scrutiny. So I've found it is actually worth running those arguments because you're never quite sure what might work. So the costs, we talked about costs very briefly. Oppositions are cheap and controllable. I've got here a range of costs of about £20,000 to £50,000. That's not my costs, obviously. I'm extremely good value for money, but this is some stats from, I think it was WIPO ran a random review of oppositions about 10 years ago. So I've adjusted this slightly for inflation, but this is a review of a number of cases that came up with this about 20,000 to 50,000 figure. Of course, you can spend what you like on an opposition. Equally, I've seen a number of cases come in significantly below this level, depending on how they're run and what the aims are. So you compare that with the national litigation. I've put a value here of £200,000. I think that's very conservative, lower end of the estimate. I think most people will realise that things like pharmaceutical litigation in the UK is running you into the millions, not the hundreds of thousands. So, and that's obviously per state. So the figure I've given, the 20 to 50,000, is for all states. So you can see it's sometimes several orders of magnitude different in terms of the cost implications. In terms of being controllable as well, there's no cost to withdraw. So you can actually file your opposition, withdraw it at some point down the line if you're no longer interested. You don't get penalised with any costs for doing so. And often the EPO will actually continue your good work and continue to examine the opposition of its own volition. And I've put here a low cost to hibernate. What I mean by hibernate is oppositions can actually be a fire and forget exercise. You file the opposition, you let it play out between the patentee and the opposition division to some extent, and you can kind of rejoin and put in as much effort at certain times as you would like at sort of key points. Pop up like an excited gopher and stick your oar in at a point where you think it's sensible to do so. But you're not being constantly drawn into the procedure and therefore the costs associated with it. So it's a relatively easy to manage cost in that sense. It's not always a good idea to. There are often procedural implications to hibernating, shall we say, and I can go into that in a bit more detail later, but nevertheless, it's a possibility. Now, there are low official fees associated with filing oppositions. I only mention this, I mean, it's a drop in the ocean for, I think, most companies, the cost of actually filing an opposition in terms of what you pay the EPO. I think what's more important is what it actually says about the EPO's philosophy towards the opposition procedure. So it heavily subsidises the opposition procedure. I think the cost of the fee is only about 5% that it actually costs the EPO to run them. And just to reinforce what I said earlier, I think what that says about the EPO is that it accepts it doesn't always get it right. It doesn't have all of the information to hand, and it effectively subsidises the public to help keep invalid patents off the register. That brings us to the end of the first part of this talk. Please join us for part 2, where I will be discussing more of the procedural aspects of the opposition procedure at the EPO.